So welcome for the next session of the SAIL Symposium. And here we have a great pleasure to invite Professor Christoph Sorge from the Saarland University. So let me introduce him briefly. So Professor Sorge received his PhD in computer science from the Karlsruhe Institute of Technology. He then joined the NEC Laboratories Europe Network Research Division as a research scientist. From 2010, he was an assistant professor for network security at the University of Paderborn. He joined Saarland University in 2014 and is now a full professor of legal informatics at this university. While his primary affiliation is with the Faculty of Law, he is also a co-opted professor of computer science. He is an associated member of the CISPA Helmholtz Center for Information Security, a senior fellow of the German Research Institute for Public Administration, and a board member of the German Association for Computing in the Judiciary. His research area is the intersection of computer science and law with a focus on data protection. So a great welcome to Professor Sorge, and his title for today's talk would be Data Protection and Machine Learning, a European Perspective.
So thank you very much for the, Thank you very much for the kind introduction and for inviting me to this conference. And I see a lot of great presenters here. So I'm really also looking forward to seeing some of the remaining talks, though I couldn't join all of them. In the background, by the way, you see one of the attractions of my home state, which is a tiny state in southwestern Germany, but with a quite renowned university. So my talk is on data protection and machine learning, a European perspective. And as I see, we have a lot of AI experts here, but I'm not sure if most of you are familiar with data protection law. I chose to do a broad introduction. So if that is boring for you, or if there's something you want to ask more about, feel free to interrupt me at any time or ask questions or tell me to skip some slides because you already know all of that. But if not, I will just continue talking. So we're talking about data protection, which is kind of a weird word. It's basically a word which is mainly used in the European context. And if you look at applications from other parts of the world, people will always or often talk about data privacy or privacy in general and mean something similar. And actually, the concept of data protection has its root in privacy. So privacy has been famously defined by Weston as the claim to determine for yourself when, how, and to what extent information about you is communicated to others. And that has influenced the legal debate as well. So the wording for the right to informational self-determination, which has been defined by the German Constitutional Court, for example, is very similar to that definition by Weston. And the importance of protecting information, is there a question? Okay. The importance of protecting information about yourself has been recognized more and more. And in the last 50 years, in many countries, there has been a development towards a legal framework for privacy. And I'm not an expert for all of the privacy frameworks across the world, but I do know a bit about the European legislation. And that's what I'm going to talk about in this presentation. So it's about the protection of some persons, some individuals, from violations of their privacy due to the processing of their personal data. So it's always about personal data, data about a person. And that's the background why there is data protection legislation. And there is also a reason why that's, at least in the EU, it's not just state or member state regulation, but it requires a European approach because we are in an increasingly globalized world, but the focus of trade within the EU is within the EU, and that requires a lot of exchange of personal data. So on the one hand, data protection should not be an obstacle to business across borders. But on the other hand, if data crosses borders, it should still be protected. So that's why EU residents should be guaranteed a uniform data protection standards across the entire EU. There has been a previous directive on data protection, but that was not really successful in ensuring that uniform standard. And that's why there is now a directly applicable law of the EU that is called a regulation. And that is supposed to ensure that uniform standard. But we're dealing with politics and, of course, very different interests across the member states and different societies. So there are a lot of so-called opening clauses, which allow a deviation to some extent from a lot of the more specific matters in the regulation. So it has been also called as a sort of mixture between a regulation, which is directly applicable law, and a directive, which basically just says the member states which goals have to be achieved. So that's the background. And the GDPR is not just relevant if you are in the EU, but also if you want to do business with Europeans. So there's that territorial scope, which means the GDPR applies for any data processing if the controller, so the entity responsible, or the processor, so that's the entity which actually does the processing, if they are within the EU. Even if the data processing is somewhere else. So if a European company based in, say, Berlin, processes data within its European activities, then it doesn't matter whether that processing is actually done in a computing center in San Francisco. It's still applicable, so the GDPR still applies. Also, even if the company is not within the EU, if it processes data of Europeans, so of persons who are in the EU, and that's in the context of doing business with Europeans. So if say a Russian company is providing a service to European customers and offering its service within the EU, then data processing for EU citizens or for people who are physically located in the EU is also subject to the GDPR. So that's the territorial scope, and it means there is some relevance even outside the core of the EU. Then there is the material scope. So the GDPR applies to the processing of personal data only, and it's focused on automated processing of personal data. There is also an exception for manual processing. So if you process manually within a filing system, like on paper, but in some systematic way, then it's also covered by the GDPR. But I think that's not so relevant within the scope of this talk, as we're going to talk about AI. The basic principles of the GDPR are mostly the ones given here. So data processing of personal data can only take place if there's a precisely defined purpose, and the data processing has to be fair and transparent. So transparent means the data subject should be able to understand what is happening with their data. There is a purpose specification or purpose limitation principle. So the purpose for the processing has to be specified in advance, or it can be changed later on, but that's subject to certain restrictions. There is a principle called the data minimization and storage limitation principle. So data should not be kept if it's no longer needed. And also you should not just gather any kind of data, because you might need it at some point, but you should try to keep the data processing minimal for your specific purpose. If the principles are violated, the controllers can be held accountable, but these principles are quite vague. So it's in principle possible to fine a controller who does not adhere by these principles, but it's problematic because of the vagueness. And that's why the GDPR specifies some of that in some more detail. In general, if you want to process personal data, then you need some sort of legal basis. So there must be a reason stated in the law which says that you are allowed to process the data. Now, there are a lot of these reasons, so that it's not such a huge restrictions. Probably the most important reasons is consent. So the law states if the subject has given consent, then the processing is allowed. That consent should be for a specific purpose, and it should be informed consent. So user should know what the consent is actually about. So if you have a 50-page privacy statement and expect the user to understand that, that's not realistic, then that will not be accepted. Another reason is performance of a contract. So if you have a contract with the data subject, then of course you can process the data that you need to fulfill that contract. I mean, that's quite obvious. Say Amazon cannot ship a parcel to you if they don't have your address. So that means if you order something from Amazon, they may process your address. Quite obvious. Also, there's the concept of legitimate interest. So that means there is some balancing of the interests between the controller and the data subject. But that is interpreted quite narrowly. So legitimate interest needs to be a really good reason and not just the vague idea I might need the data at some point in time and therefore can process it arbitrarily. There is some more protection for so-called special categories of personal data that includes genetic data, biometric data, sexual orientation, political opinions, and some more, which a lot of people would consider as sensitive. So for that, you need even stronger justifications to process these data. When you process the data, you have to inform the data subject, and the law states that that information has to be in an easily accessible form, easy to understand, and using clear and plain language. So basically, any normal person should be able to understand what is happening with their data. That must be provided when the data is collected from the data subject. So you ask the person to give you some of their data. Then you must also give them that information. But there is also the case if you obtain the data from somewhere else, even then you have to provide information to the data subject subject to some limitations. And that includes the contact details of the controller. So who is processing their data? For what purposes are they processing their data? Is there any sort of automated decision-making using that data? And if there is automated decision-making, then meaningful information about the logic involved. So by logic, they mean the programming that is done, or the general concept of the data flows, as well as the significance and envisaged consequences of such processing for the data subject. And that is going to get relevant for machine learning because it's usually quite difficult. But we will get back to that when I talk about the actual main topic of the talk. Also, the subject has to be informed about their rights. And those rights include the right of access to the data. So if someone else has gathered information about you, you have the right to obtain confirmation whether they have that information and the right to obtain a copy of that data. There is the right to erasure, or also called the right to be forgotten. That means when the processing is no longer necessary for the purpose, then this data subject can request that data to be deleted. And that is just two of the rights. There are some more, but we don't have time to go into details about all of them. If the rights are violated, then the data subjects may claim a compensation. But in Germany or in the EU in general, those compensations are not the huge sums that we might know from the United States. So something like €100 compensation might actually happen. That would not be unusual. So we're not talking about millions here. One important right, and you could call it a meta right, is the right to lodge a complaint with a supervisory authority. And we will get back to those in a moment. There is the concept of privacy by design and by default, or also referred to as data protection by design and by default. That means if you process personal data, you have to have some technical and organizational protection measures, or TOMs, already when you start the processing. These TOMs may include pseudonymization. So it's not necessarily anonymization, because remember, the GDPR only applies to personal data. If data is anonymized, then it's no longer personal data, and we can forget about the whole data protection law. But there is something in between where you try to protect the data, but know that it's still personal data, and pseudonymization might be such a case. The required technical measures vary according to the case, so it depends on the cost and the risks. So if it's just about your book order from Amazon, then if someone else gets to know something about the book order, might not be as critical as health data, which is stored at your physician. There's the privacy by default concept, which says that the require needs to set any default settings as privacy friendly as possible, like opt-in instead of opt-out. And that's the result of the so-called privacy paradox, that users say they want privacy, but don't usually, or in many cases, don't set up their preferences accordingly, because it might be an effort. Finally, I wanted to mention in that introduction part of the talk, there are the supervisory authorities. So in each member state, there is at least one independent public authority which monitors the application of the GDPR and to which you can complain. If there is an infringement, then the authority can investigate that infringement, so they can request access to the, say, the company's offices for such an investigation. They can issue a warning, or they can just ban certain processing, which is very rare, but could theoretically happen. And there can be an administrative fine, and that fine can be quite substantial. So the limit is up to 20 million euro, or if in case of company, up to 4% of the total worldwide annual turnover of the preceding financial year. So if you imagine that would be Google, then the 4% of that annual turnover would probably be a bit higher than 20 million euros. And it's not the profit, it's the actual turnover. That's the upper limit of the fine. Now, the authorities don't usually go up to that upper limit, but these fines can be really quite substantial. So there have been fines up to something like hundreds of millions of euros in extreme cases. So, so much about the introductory part. I mean, if there are any general questions about the GDPR, you could ask them now. But now I would like to talk about machine learning and how that might be relevant to data protection, and specifically to the GDPR. And I think that's the more interesting part of the talk. So the promises of AI, and more specifically machine learning, include, well, we can get a lot of new information by detecting patterns or dependencies or correlations in large data sets. We can do that across domain or application boundaries, and I'll talk later about what I mean by that. Those are represented in a model, usually in a machine learning model, at least if we talk about supervised machine learning. Even if the patterns are not immediately comprehensible for humans. So, you know, neural networks, they recognize these patterns, but you cannot look at the neural network, or at least I cannot look at the neural network and then see what it does. And in many cases, they do that with a higher reliability than humans. So it's quite tempting to outsource decisions to a machine or to a machine learning algorithm. And I will talk about the problems of these developments now. So the first issue that I've seen is pattern recognition. So I came across that paper here, which looked at pixelated or obfuscated images. And they have been quite successful using deep learning with neural networks to identify with reasonable accuracy a lot of persons whose images had been obfuscated. And that means it's just one example where machine learning can be used to de-anonymize data. Anonymization is essential for data protection. As I said before, if you have personal data, then data protection law is applicable. If you have anonymized data, then data protection law is no longer applicable, and people might be tempted to basically just publish the data or keep the data without thinking of any of the subject's rights or any of the limitations of, say, the GDPR. So to analyze whether data is personal data or anonymous data, the GDPR or its recitals say something like you have to take into account the effort and the cost that would be needed to identify a person based on that data. The exact wording is slightly different, but that's the gist of the regulation. So if a controller can de-anonymize the data, find out which person is behind the data with some reasonable effort, then it's personal data. That means with technical progress, previously anonymous data might suddenly become personal data again because of the development of new tools. And I don't have a solution for that. I just want to mention that is some relevance of machine learning techniques to data protection law, and specifically the GDPR. That pattern recognition gets more promising if you collect more data about an individual and if you collect data about as many people as possible. So that's probably not true for each single application, but I was thinking of something like speech recognition by a lot of companies, say Google or Amazon, and that's usually done on the companies or the providers and not on the users' devices. Of course, it would be more privacy friendly if the speech recognition would only be done locally, but that would also mean they would have less data available in the companies to optimize their speech recognition algorithms and the parameter tuning for the development of the technology and so on. So you might want to argue that the data minimization principle and the privacy by design principle would force companies like Amazon and Google to do the speech recognition on the respective end users' devices. But I don't think that's the intention of the GDPR, because that would be technically probably inferior. And for that reason, data protection law would not force the companies to do that most privacy-friendly option, because there has to be some reasonable limit to that. So then the GDPR's mechanisms might not be sufficient to resolve that potential issue, that it's lucrative for companies to do the processing on their end instead of on the user's premises. But there we might think of other fields of law, like that might be related to the market power of those companies. So competition law might come into play there. So data protection need not be achieved only by data protection law, and that's a new legal development to also think of competition relevant aspects of data processing. And I think machine learning, which benefits from large amounts of data, and therefore could lead to a natural monopoly, is really a relevant example for that. Okay. The next issue I wanted to mention is the cross-domain combination of data. So you have different application domains, and you can get some relevant new information from combining those. And also not just new insights in research, but it can really lead to new applications. And one example, which I think is quite famous, is for medical research. I think that was by Apple researchers, at least researchers collaborating with Apple, who found out that certain heart diseases, don't ask me which ones because I had no idea about medicine or physiology, but certain heart diseases can obviously be recognized by looking at these variables, those fitness trackers, which record information about your pulse. So basically that's a fitness application or used in your leisure time when you go jogging or cycling, whatever. But it can be used in the medical field as well. And there are probably more cases where the combination of data from different domains provide new insights. For example, you look at the search queries of a person and their postings in social media, and their appointment calendars and flight bookings and their online shopping preferences, like their dietary preferences and timekeeping at work. And from all that, you might derive how stressed a person is. Should they take a vacation? Are they at risk for a heart attack? Based on that. So you might think of a lot of applications by combining the data across domains. For example, I made up that table once for those fitness applications. You might look at one-dimensional data about one person, like a person just watching their weight over time for health applications. You could do that across multiple users to enable competition, who runs the fastest, the longest, who does most for their physical fitness. You could also have multi-dimensional data, like not just the weight, but also the pulse and the time used for workouts, stuff like that. And you could use the multi-dimensional data across users to get new insights. So for that case here in the upper left, the privacy enhancing technology, users' privacy are well understood, and you can usually anonymize the data and get around data protection law. But here, the interesting part and the aspect where you get the most significant benefit from machine learning or AI is probably here in the lower right corner, just using multidimensional data about multiple users for research, like medical research, for example. Now that sounds promising, and for example, myself, I would like to live as long as possible. So I would be interested in having good medical research and find out about potential conditions as early on as possible. However, we have the purpose specification or purpose limitation principle in the GDPR. So data should be collected for a specific purpose. There are exceptions to that principle, and that includes a research exception. So you can, in fact, under certain circumstances, use those data which were collected for one purpose for another purpose which is related to research, or which is a research purpose later on. So that is possible in principle, but subject to limitations. There is the data minimization principle and the concept of data protection or privacy by design and by default. So when you do specific data processing, you should know beforehand which data is required for that processing. And if there is an attribute that you're learning which does not actually help you with your application, then you should not get that information in the first place. Now, there are really obvious questions like maybe one attribute is not really useful for the specific application, but maybe in combination with 10 other attributes, it becomes relevant, and a machine learning algorithm could actually use that. Now, that has not really been discussed in the legal domain, how to deal with that issue, that you might need more data, even to learn about new possible applications or new research insights. So here, actually, there might be a small conflict between the GDPR and machine learning applications and also medical research, for example. If you want to use consent as a legal basis for processing, I mean, with the user's consent or data subject's consent, you can basically do anything. But there is the question whether informed consent is actually possible. especially critical in case of special categories of personal data, such as health data. So if you just have a vague idea, well, we want to put your health data into some sort of machine learning algorithm, then that might not be enough for an informed consent. And you have to check that individually, but there might be an issue here because deep learning and actually understanding the model as hard as a computer scientist, but for an average person, there's probably no chance at all to do that. So here we do have some potential conflict. Talking about models of machine learning, in particular, talking about deep learning, there has often been the implicit assumption that when learning from personal data, the learning process includes an aggregation and abstraction, so the result would no longer contain personal data. Now, I guess in recent years, all of us has learned that this is not always correct. And there are many papers about that. Probably there are people who know more about these papers than I do. But one example is membership inference attacks. That means an attacker could conclude whether a specific data set was part of the training data for that model or not. And in many machine learning models, that is at least not guaranteed that they don't contain any personal data, or more generally, that you cannot derive any part of the training data from the model. Because the standard evaluation is about the accuracy and the expressiveness of the model, but not about whether there is too much data in the model, or whether there are maybe irrelevant attributes in the model which would not be needed for the actual model, but which are there, thereby violating the data minimization principle, or whether the model allows conclusions about individual data sets, or in the end, individual persons from the training data. A traditional example for that has been the autocomplete function of smartphone keyboard apps. But I guess there are many more examples for the issue. So that one consequence of that is that the GDPR would still be applicable for those machine learning models. So if the state of the art enables the controller of that model to get some personal data out of the model with a reasonable effort, then it should still be considered as personal data and is therefore protected by the GDPR and also other data protection legislation around the world. Also, how about the right to erasure or the right to be forgotten? You cannot simply take one person's data out of a machine learning model, at least not in all machine learning algorithms. So does that mean if one of the persons whose data was used in the training demands the data to be erased, does that mean we have to throw away the entire machine learning model and relearn everything from the beginning, which might be a huge effort? So that is something that still has to be discussed in the legal community as well. One way around that, of course, is to try and use privacy-preserving machine learning approaches. But as far as I know, with the current state of the art, there's usually an impact on the accuracy of the model in that case. And that might not always be feasible or what you actually want. So just one option to keep in mind. So we've learned that the GDPR and other data protection law might still be applicable, even though we are just looking at the model, which is an abstraction, but might contain additional data. But there is another issue with the model. We have the concept of transparency of data processing. And also we have these information rights that I mentioned previously. So when you inform, when you collect personal data from a person, you have to inform them what is happening with the data. And in case of automated decision, you have to inform them about the involved logic. So at least the general gist of the how the data is used to get to a certain decision. Not the details, not parameters of the algorithm, but at least the general idea. Now the question is, yeah, how to give more or better transparency. I mean, there are the simple models. If you learn it, just a decision tree, that's easy to understand in principle, though of course it might also get too large for a quick overview. But in a neural network, at best, an actual machine learning expert can understand what happens within that neural network. For example, I have dealt with machine learning superficially for something like 15 years now, but I will not be able to explain to you how a neural network gets to desired output. And that is why the research on explainability of the results is very important. I think there is another talk at this conference which goes into a bit more detail about that. Personally, I doubt whether the explainability will be achieved in all cases, because I think sometimes really the facts are just too complex to explain them easily. That's when the human being would have a gut feeling. So there have been so many factors coming into that decision that you could not explain your own decision. And I think that the same may happen with neural networks. But as I said, I'm not really the expert for, say, neural networks. So someone might be able to correct me there. But keep in mind that transparency is a requirement from a data protection perspective, but might also be relevant from other legal perspectives. Say, if there is a claim that a machine learning algorithm leads to unfair discrimination, one approach, one of the possible approaches would be to explain the decision and thereby to show whether or not there has actually been illegal discrimination. So explainability is continuing effort. And just to look back at data protection, we have that articles 12 and 13, but also the general the general principle of transparent data processing. So there is no real result of the legal debate how transparent a machine learning algorithm should be. So that is ongoing research. I just mentioned that concept of decisions by machine learning which might be discriminatory, and that is particularly relevant for automated decisions. And there is also a rule for these automated decisions in the GDPR. And the basically the general gist is it's called a ban on automated individual decision making. So in general, it's forbidden to have automated decisions which affect an individual to a certain extent. So there should be, or there has to be some legal consequence to the decision, and only then is there that actual ban. But there are exceptions, and there are so many exceptions that it's not really a ban on automated decision making. They are allowed, and that's the exceptions, if the automated decision making is necessary for entering into or performance of a contract between the data subject and the data controller. So that's the first one. That's quite a huge exception. So say automated decisions on banking, so credit decisions, they would be covered by that norm. They are also allowed in the case of explicit consent, but once again, that should be informed consent, and you have to provide the general logic of the automated decision, which makes machine learning a bit more difficult. And also, there might be other legal regulations which allow automated decision-making. And that might be all kinds of different laws. So there might be laws in the banking sector, for example, regulating in more detail the automated decision for credit. So in that case, that would also cover the automated decision-making. If, however, the automated decision-making is permitted, there have to be protection measures, so the rights of the individuals are not violated. And these protection measures include the right to obtain human intervention on the part of the controller. Also the right for the data subject to express his or her point of view and to contest the decision. So what is always allowed is a human decision which is supported by AI, or if the decision is actually made by the machine, then it has to be verifiable by a human being. However, there is no check about the qualification or the authorization of that human being. So the human being must be able, in principle, to overturn the decision. But if the person always agrees with the machine, then that's perfectly fine from a legal perspective. And that's why the German legal literature used that image of a blunt sword. So in general, it sounds like it's an enormous restriction on automated decision-making about individuals. In practice, you can get around that quite easily in most applications. So it's not really an issue for machine learning. There are more challenges for machine decisions outside of data protection law. And because I'm talking about data protection law here, I just want to briefly mention them. That could be the protection of personality rights, or I mentioned before the concept of discrimination by machine decisions. So the anti-discrimination legislation also applies to machine decisions. And you know that this is a huge ongoing research effort, both from the technical side and to a certain extent from the legal side, though I think they are not talking enough to each other on the both sides. But they are talking, and there are good examples for interdisciplinary papers on that. The potential benefits of the data subject should not be forgotten in that discussion. So if you think that machine decision is unfair, you can look at the algorithm, you can test the algorithm, get some explanation and transparency to some extent. Probably not as much as you would want, but it's better than just to be fired based on a gut feeling, because the AI can be verified in principle. And the fact that you can test and check, that means that some legal challenges, like in anti-discrimination law, only become visible due to AI. So the issues were there before, but AI enables checking that you could not do for the human decision. You cannot look into someone's brain, but you can look into a machine learning model, at least in principle. Now, at the end of my talk, I want to mention one more topic, which is not a traditional data protection topic, but it is still relevant, and that's malicious attacks on machine learning models. So the attacker might analyze a trained model and then construct an input to enforce a specific output. And there's that well-known example of some stickers on a stop sign, which lead to a misclassification. In that example here, it's 100% misclassification under lab condition. And there could be more. There could be backdoors in a machine learning model. So if you get data from from a large group of people who are contributing to the model, and in that case, a backdoor could enforce a certain decision given a specific input. And also there, the attackers have been quite successful in research papers. And that should be taken into account if you want to use a machine learning algorithm. From the data protection law perspective, at least according to the GDPR, if you expect a high risk for the rights and freedoms of natural persons, then that might require a data protection impact assessment. So if the machine learning algorithm decides to output certain warnings or to perform certain actions which are risky to a natural person, then that has to be checked. So there has to be an analysis how big the impact would be and how big the risks would be. And that is quite some effort. So that might be necessary if you know about these potentials for attacks and if your application might be vulnerable to them. So much about the current state of law in the European Union. You might have heard that the European Commission is proposing a new regulation on AI called the AI Act. So that would be just the first step in a legislative process, and we can be certain that it will not be passed as is at the moment. There will be discussions. The parliament will be involved. So in the end, it will probably look different, but there is a chance that this legislation will be enacted in a couple of years. And that AI Act is proposing to restrict risky AI systems. So that includes high risk, like safety critical AI, but also stuff like AI that could discriminate against specific persons, like exploiting vulnerabilities of specific group of persons due to age or disability. And if that can cause harm, then the AI would be completely banned based on that proposed legislation. The legislation also suggests organizational measures like risk management and the establishment of supervisory bodies for AI. And that's actually what a group of colleagues and I suggested in a study a couple of years ago, that this might be necessary for certain applications. And that proposal includes some aspects which are relevant to privacy, like it restricts social scoring and biometric identification in real time. But in general, it will not deviate that much from the current GDPR concepts. Okay, so much about my talk. To conclude, I wanted to stress that the GDPR is relevant not just in the EU. That's first of all because it's relevant for companies doing business with the EU, but also because there is data protection legislation which is more or less similar to the European legislation in other areas as well, so not just in the EU. Many aspects of the GDPR are relevant for machine learning. I mean, sure, it's about data processing, and machine learning is data processing, so yeah, it's relevant. It's important to keep in mind that even if you just have a machine learning model, you have to check whether that still contains personal data. So if you can derive information about some identifiable natural person from that model with a reasonable effort. In that case, the GDPR or other data protection law as well would be applicable. I think that, yeah, there has been a lot of research in recent years about many of these aspects, but we would still need more effort in the interdisciplinary collaboration between AI research, the technical data protection or privacy research community, and the legal data protection research community. So getting all these three together is, I think, really important issue for the future. And well, in the end, my question is the GDPR now a success story about the protection of individuals' rights, or an unnecessary barrier to innovation? So I would also be interested in your stance on that. Personally, I think the GDPR is generally quite successful. And I think the barrier to innovation is not as big as it seems to be, because we can handle these restrictions and we can use anonymization, improve the research efforts on privacy preserving machine learning, and just raise the awareness of what machine learning models do. So I think it's not a huge hurdle or barrier to innovation, but has to be taken into account. And that stands as one example of data protection legislation, because I am a European, but the same concept is in other legislations as well. With that, I thank you for your attention. I've seen that there are already questions, so I'm looking forward to the discussions as well. But I think someone is going to moderate the discussion. So I will hand over to whoever is doing that now. Thanks.
So thanks, Professor Sorge, for the wonderful talk. I mean, it's quite different from the other talks maybe in this symposium, but it's a very important topic with the GDPR. Yeah. Yeah, so we have a few questions. So I guess you can see them also, but let me read them out.
Yeah, okay. Yeah, I can read them as well. Just wanted to not want to destroy your concept of the Q&A.
Sure.
So should I just do that myself? So just go through the Q&A.
Let me read it out, then you can maybe
Okay,
answer.
sure. Okay.
Okay, so Ashwini is asking, so how long is the consent given valid? For example, if the consent is given for one transaction, can it be used for the same purpose again or within the purpose limitation requirement? Since there is no requirement of notification before processing, is this possible?
Yeah, sure, that's possible. Basically, there is no fixed expiry date for the consent in the GDPR. There's just that general concept that it has to be understandable. So as long as the user knows what his consent covers, then it can be consent for the next 20 years, but it can be revoked. That's important to know. So it can be basically indefinite, but you can revoke it at any time. But the example given here, you can just use the same consent and gather data, say a smartphone app that gathers data about you. You can ask for the consent once and then gather data for many years.
Okay, hope that answers the question. So the next question is from Abhishek. So he thanks you for the informative talk. And his question is that I'm actually interested in another recent directive by the EU, that is the Omnibus Directive. How effective do you think this directive will be in the context of transparent and responsible AI? The Omnibus Directive.
Okay. Actually, I have not dealt with that. I've heard about the directive. It's about consumer protection, but actually, it doesn't make sense to try to cover that because I haven't checked that there is some information duties which might be relevant for probably recommender algorithms, but I would have to look into that. So maybe we can exchange email addresses and take that offline because
Sure.
I don't really know the answer.
Yeah, so maybe we could unmute Abhishek for a minute so that maybe you can.
Yes, Abhishek, you can unmute yourself and ask your question.
Hello?
Hello?
Yeah.
Yes, you're audible. Yeah, go ahead.
Am I audible?
Yes, you are audible.
Yes, Abhishek, you are audible.
Hello?
Yeah, you are audible. Okay.
If not, I mean my email address is
so maybe yes.
available on
So
the
I
website.
think there is some problem with the connection. So fine. So yeah. So maybe Abhishek can ask.
Oh, okay. So basically, my question was more regarding this omnibus directive, which is also like there are some consumer protection aspect to this, as well as it is also useful in some of these antitrust issues, like let's say the handling of data of say bodies like Amazon for the third-party sellers and these private label products, which they actually steal the ideas from different third-party sellers and produce some products of their own. So all those fiascos. So this directive was basically regarding that, if I understand it correctly. But like, how effective has it been, or will it be? Like, what is the discussion in the European research group? That is the thing that I wanted to know.
Yeah, so and actually I have to admit I have no idea about that. Sorry for that, but it has not been discussed so much in the data protection community, because if it had, I would know about that. But I'm not in those discussions about competition law or consumer protection law, so I would have to check that with a colleague. Sorry for that.
Okay, thanks. So so let me move on to the next question. So it's by Professor Manchikanti. So just to introduce her, she's a professor at the law school at IIT Kharagpur, which is my institute also. So the IIT Kharagpur has a law school, like the Rajiv Gandhi School of Intellectual Property Law. So she's a professor there. So the question is as follows. So we research on the regulation of AI in healthcare. I have been concerned about verifiability of data when there are no electronic medical records. How do you envisage development of scoring or indices for improving trustworthiness of AI?
Okay, now that's a very good question. So verifiability of data is basically, just to make sure I understood the question correctly. So you have some input into a machine learning or AI system, and you want to be sure that actually the training data is correct, and that would be the basis for a correct decision and trustworthy AI. Is that the question?
Yeah. So, can you see the question? Yeah.
Hello, Professor.
Hi, nice to
You
meet you.
can unmute yourself and ask the question.
Good morning, I guess, for you out there. It was a very informative talk. And
Thank you.
I just wanted to ask you that we work on the regulation aspects of AI, where as you rightly said, we are looking at data that is collected from based on AI or AIML based processes. So when the data is being analyzed for, let us say, a particular disease, and there are going to be accurate predictions out of that, all of the data is not in the digitized format. That is one problem. Second thing is that some data is in the digitized format and some of it is in the non-digitized format. So when you're looking across a single data point, sometimes across multiple data points, there could be serious difficulties and constraints in arriving at some kind of accurate diagnosis close to a physician's diagnosis. So that is where we have a concern on these technologies, on the verifiability of these. How much?
Yeah, I understand, because Germany is also a quite analog country, so a lot of the records, including medical records, are still on paper. So we basically have the same issue here and probably in many other countries across the world. But I don't see any regulatory aspects of the GDPR that would really help there. I mean, the GDPR does not prevent digitalization of data. I mean, many people claim that we cannot digitize because we have to keep data protection in mind. But of course, you have to keep in mind the technical and organizational protection measures when digitizing the data. So to make sure that access controls are guaranteed, stuff like that. But I don't see any, or I'm not aware of any approaches that try to consolidate the data from paper and electronic records. So I'm afraid, that's another question where I don't really have a good answer.
Okay, thanks. So yeah, so let me move on maybe. So the next question is by Ashwini. How practical is the objective of irreversible anonymization? Isn't there always a risk of re-identification?
Yeah. Well, I mean, with concepts like differential privacy, there are some anonymity properties that you can prove, and I say that carefully, anonymity properties or anonymity-related properties that you can prove. I guess for practical applications, yes, there is usually a risk of re-identification, and the GDPR does take that into account. So it's basically not if there is some theoretical possibility of re-identification, but it's only considered if it's practical for the respective controller. So if the controller of the data, so the person who has control of the data, has no way to re-identify the person with reasonable effort and reasonable cost, then the data is considered as anonymous. But it does take the technical development into account. So if you know that you can buy a software to re-identify persons in half a year, then the data would not be anonymous. But say in practice, that does not play that much of a role, because most attacks on anonymity or re-identification are using quite old principles. Like if you read the original paper on k-anonymity, then a lot of these attacks are already described. So I hope that answers the question.
Okay, thanks. Maybe a couple of more questions I see. So Meenakshi would like you to explain a bit more about the blunt sword.
Yeah, so that was the wording that some authors used to describe the regulation on automated individual decision making. So basically, it says you cannot make a decision about an individual automatically if that has legal consequences for that person. And that sounds as if it was generally forbidden, and it sounds like say a very effective weapon of the law against these automated decisions, which might be disadvantage to humans. But then if you look at the details, you can get around it very easily, because if the machine just suggests a certain decision and the decision is then officially done by a human being, then it would be legally acceptable. And that means it looks like a strong legal instrument, but in essence, it's just a blunt sword because it's not really useful, or it doesn't achieve the intended purpose, which might be a good thing after all, because automated decisions don't have to be bad, but it is not what it looks like at first glance.
Okay, and the last question from Janardana. Can you please give us an idea of how you are processing obfuscated subject data that is privacy protected? Are there any algorithms existing for that?
Yeah, I mean, of course, it depends on the application scenario. I mean, if you're just interested in research, so you want to find some correlations between different attributes in human beings, then you don't need to know the identity of these human beings. Now, the issue is how to get rid of identifying information, because there a lot of information may be used to identify a person. It doesn't have to be the name, right? If you have like my location data, which shows you when I move from a certain address in the city center to a certain building of the university campus, and I do that every day outside the pandemic, then you can probably identify me even if you don't know if my name is not in the data. And there are a lot of these identifying attributes. So the approach, if you're just interested in statistical information, then that would be either k-anonymity with its limitations, if you want to look that up, or differential privacy. And in essence, that means the statistical information is still there, but it's you add enough noise or restrict the data sufficiently, like remove enough attributes, so a data set might always belong to more than one person. Or in case of differential privacy, the statistics don't even change if you just, or with a large probability, they don't even change if you remove my personal data from the data set. So that is the approach. Of course, if you want to recommend something to an individual, say you have a recommender system, then not identifying that individual becomes very difficult, because you need to know some profile of that person. But for any research or statistics-based application, those privacy-preserving machine learning models, and if you Google that with Google Scholar, you'll find a lot of these approaches. They can actually be very useful.
Okay, and I see one last question. Maybe we can just take it. So it's by Ashwini again. The material scope of the GDPR applies to personal data which form part of a filing system.
Right.
Is that,
so that,
or a filing system? Yeah. Is the distinction between structured and unstructured clear?
Yeah, so basically, maybe we can tell you what the legislator had in mind. So basically, if you write information about individuals on a piece of paper, then that might also be a systematic data processing which needs to be protected. And as you assumed, if you can look up based on a certain criterion, like if it's ordered alphabetically by last name, then that would be structured according to a specific criterion, and then that would be considered a filing system. So yes, it's a distinction between structured and unstructured data. But keep in mind, that is for non-automated processing. So for processing, say, really on a piece of paper. For automated processing, so processing with a computer system, the GDPR always applies.
Okay.
I hope that answers the question.
Yeah. Yeah. So thanks again, Professor Sorge,
Okay,
for
thank you.
answering all the questions. And thanks to the attendees for attending this session.